Collateral source rule in Missouri. Hi, my name is bajric&ramic, a car accident lawyer here in the St. Louis area. And today's topic is going to be the collateral source rule here in Missouri. And so to explain it, I'm going to give you a few scenarios and then you can kind of see how that rule has weakened personal injury car accident claims and the injured party's right of recovery. So back in the 90s, before 2005, the jury in Missouri was allowed to hear the actual amount billed for a medical bill from the hospital. So let's assume the medical bill from a hospital was $10,000. The person had health insurance, there were discounts, and then the health insurance paid only, let's say, $2,000. Back in the day, before 2005, the jury in Missouri was allowed to hear that the actual amount of damages was $10,000 for those medical bills. No discounts were allowed to be seen by the jury. Basically, the reasoning behind it was, why would we allow the wrongdoer, the person that caused the accident, to get a pitfall because the injured party had health insurance at that time? And then in 2005, that rule changed, and with the tort reform, now all of a sudden the jury was allowed to hear that the actual amount to satisfy the medical bill was, let's say, $2,000. However, the injured party was allowed to rebut that presumption and still show to the jury that, hey, the actual cost of these medical bills was $10,000. And then the jury in Missouri was left to decide what amounts they're going to consider. And then back in 2017, that rule changed again. It eroded further the injured party's rights, and it said that the only number that the jury will be allowed to see is the number that's able to satisfy the medical bill, meaning the $2,000 number. Okay, and so what does that really mean for injured parties in Missouri? Well, if you have got health insurance, if you are a responsible individual and you are paying your premiums to have health insurance, the at-fault party is now allowed to use that against you, meaning they can use the discounted numbers. So in the scenario that we used previously, accident happens, injured party goes to the hospital, the bill is $10,000. If the party had health insurance, that bill will be $2,000. If the injured party did not have health insurance, so they're not paying their premiums, that bill will still be $10,000. And as you can see, the party without health insurance will be allowed to collect more money than the person that was responsible and had health insurance at the time of this collision. So basically, the collateral source rule is really punishing you if you had health insurance at the time of this collision, and it has eroded plaintiffs' claims over the last 15 years. So I hope this kind of explained the collateral source rule. If you have any questions for me, give me a call at 314-352-6800. Thank you.